Otherwise, we can apply for certified copies. Inspection of certified or certified. Your Lordship may need it, my lord, for judgment writing.
So after the judgment is delivered, then we'll return it back to you.
Yes, in the meanwhile, parties can apply for inspection or certified copy.
Of the CBI report. So the CBI report will be maintained with.
Yes, that's all I'm requesting.
Because an investigation report. Otherwise, the whole investigation may be derailed if we disclose it at this stage.
Can I? Lordship says it's not right time to mention. Item 6 and 9 I'm mentioning.
Yeah.
These are the two matters. 9 is Shiv Sena, 6 is NCP. Yeah. The Lordship had intended to have it urgently heard, but NEET overtook us. The Lordship may give us the shortest possible.
I appear for the respondent.
I'm at that moment asking. 1 second. I'm asking for the shortest possible time. That is 9th. Otherwise, the thing is completely infructuous. One way or the other, elections are there.
Volume 4 SCC 631. I'll not read.
2021.
Volume 4 SCC 631. This was also use of unfair means. My lords were pleased to, my lord, consider the case law on the subject and, my lord, observe at page para 56. And I would rely upon respectfully on the last part, but I'll read that para. The decision in railway recruitment, etc., all go to emphasize that the recruiting authority is entitled to take a bona fide view based on the material before it, that the entire process then vitiated, as a result of which a fresh selection process should be initiated. The integrity of the selection process cannot be lightly disregarded by the High Court, substituting its own the material which has been taken into account by the decision-making authority. Undoubtedly, fairness to candidates who participate in the process is an important consideration. There may be situations where candidates who have indulged in irregularities can be identified, and it is then possible for the authority to segregate the tainted from the untainted candidates. Now, please note this, my lords were pleased to say this. On the other hand, there may be situations where the nature of the irregularities may be manifold and the number of candidates involved is of such a magnitude that it is impossible to precisely delineate or segregate the tainted from the untainted. A considered decision of the authority based on the material before it, taken bona fide, should not lightly be interfered in the exercise of powers of judicial review unless it stands vitiated on the grounds of unreasonableness or proportionality. And, my lord, the decision-making process, my lord, I have shown to your lordships, it matches pan-India. There is no spurge. It matches earlier year and the year before that. And even the investigation suggests a localized, identifiable irregularities. And therefore, your lordships may not, my lord, exercise the judicial review. That's the respectful submission. Last, my lord. Last, the question, my lord, that wrong and right question. My lord, I have also received several mails from unknown people, and I don't wish to rely upon it, but the common thing, my lord, common thread which is coming is that there are old books which are available. The old books contain answer, but in the of NCERT book,
your instructions say that you must go by the latest edition.
No, but the instructions say that in case of disputes,
how can we have? And the thing is, option 2 and option 4, there may be a situation where the question is ambiguous, and possibly both may be correct answers logically speaking. In a given case, that you have 4 options. Option 2 may possibly be a correct answer. Option 4 may also is really the correct answer, but option 2 is also so ambiguously framed that it may also be correct. In a given example, here if you look at the answers, each of them excludes the other. each of them excludes the other. Let's
Lord, I'm just making an attempt.
let's just see that वो मेरा IT director का
Lord, if your lordship sees the question, Lord, for a second, it's a trick question, Lord. I won't say, Lord, it's a ambiguous question. It's a trick question.
Yes.
Statement 1, I may not read. 2, again I may not read. Now see the question. In light of the above statements, choose the most appropriate answer from the options given below. No, not the correct answer. Which is the most appropriate? There may not possibility of 2 and 4 both being correct.
But see, option 2 is both statement 1 and statement 2 are correct. 4 says statement 1 is correct, but statement 2 is incorrect. So both can't coexist together.
I understand. One rules out the other. I cannot defend, my lord, something which is not. But, my lord, kindly appreciate, my lord, the wrong answer published by NCERT book since years.
Now, just for factual clarity, the wrong answer is option 2. We are taking it as option 2, though in our order.
It may be.
We will just mention. We'll mention the question because the question number etc. may be jumbled. So I'm not sure the options are jumbled also. Options may not be jumbled, right?
Options are also jumbled.
Right. So options. So we will just so that there is no.
Better to quote the.
We'll just quote the question. Now tell us one thing. What the option 2 appeared as an answer in which NCERT edition?
Yes, Lord, that appeared.
Your Lordship, prior to 2019. In 2019, the edition has been changed.
No, that appears to be not a very correct information. Lord, my information is up to 21, it continued. But subject to, Lord,
Your Lordship.
Lord, if some student can come, Lord, the old question, old wrong answer, till what time it continued in NCERT book? Till 22. Yes, the revised edition came in November 22. One of the students wrote me a mail that before that we have already started preparing.
Your
Revised
Lordship,
edition came in.
what Mr. Tushar Mehta is saying, what my case is, I started preparing in 9th grade itself, from 2020 onwards. So I bought all these books in 2020 itself. I have a copy of edition in my petition. I have annexed that 2019 had the same statement, which was revised in 2019 October, and thereafter in 2023 as well. The same statement has come into being.
I think what we should do is, we should not go by the edition and all that. We will go by the correct answer. Now, let's take an extreme case. Let's take a case where the latest NCERT edition gives a wrong answer. But a student who has prepared well gives you a correct answer. Will we give that student?
I get, what your lordship is calling from you. But
IIT tells us what is the correct answer.
Lordship, the idea is to have correct knowledge on the subject matter, Your Lordship.
Only a minute.
Yes.
Look, at the same time.
Yesterday we referred it to IIT with your consent.
No, I consented.
Let's go by the IIT.
The respectful submission is this, and I leave it at that those who relied upon an authorized text of NCERT and given the option accordingly, should also not get the disadvantage of it.
No, Mr. Mehta, the question here is not about the correct question, rote learning. You have to have the fundamentals there. So far as an unstable atom is concerned, it has to be a radioactive. Then it becomes unstable. Otherwise, protons, neutrons.
I am not joining.
So being a science student, I am a little bit aware of it.
So the matter is,
the answer is so clear. If anybody has his fundamentals clear, he will answer it. So if he is bound only reading textbooks which are incorrect, he will render incorrect answer.
And though we gave the director time until 12, before 10 o'clock we had it on our paper report.
Would not have taken more than 2 minutes.
It would have taken probably 10 seconds to answer the question.
But the persons who will be affected would be around 4,22,000.
Your Lordship, but that also has to be considered. How many of them are within 1,08,000, Your Lordship?
No, everyone would be. They may come, they may go out. We do not know how will.
Your Lordship, the inflation itself is the big bug in this entire examination, Your Lordship, due to only this question marking. No, 290. 256 or something.
I tell you.
Was given by 9,28,379 students. The larger proportion were all giving the correct answer. Option 2 was given by 4,20,000.
Your Lordship, the challenge was made by less than 0.6% of students. Who challenged this question?
Basically, my lord, without going into which answer is correct, my lord, treating 4 to be correct. Lord, only one last request. Only one last. Lord, question number 4 is the correct answer.
Wait for you to wrap up for a minute. You will not close your argument right now. Let's just hear.
Yes.
So that's the perspective of students that others who lose, who stand.
Your Lordship.
So let's see what. Don't just keep your thought with you.
Yes.
Where you are.
Can we circulate a note? The main argument here is this applicant, she is AIR 1. She is scoring 720 out of 720. While attempting this question, she was faced with two situations. There's a tabular chart on the second page. If she would not have attempted the question,
She is rank number 1.
rank number 1, 720 out.
720 out of 720.
Yes. if she would not have attempted the question, it would have been -4 for her. So she would have ended up scoring 716. If current situation is executed, now if the current choice is treated as incorrect, that will be -5 for her. So this will be 715. So now she is in a peculiar situation where she will end up getting even lesser. If she would not have attempted the question, she would have been at 715. Because the second difficulty is that in the information bulletin, there is no whisper at all of the fact that there's some new NCERT book which is to be referred. And the old NCERT book is very well on the website also. Because we have made an argument that the rules of the game cannot be changed in between. If my lords may see one judgment, 2011-10 SCC 51. It's the rules of the game, if I may just read the relevant part.
Instruction that if there is a dispute regarding the answer, then the answer given in the NCERT will be treated as correct. Is there any instruction of that nature?
Well, as per...
So, is there any such instruction? No. So, the answer has to be correct on principles.
This judgment, one more thing, very sorry. One very important thing in the FAQs which they released post declaration, what do they say? This was also done as a policy mentioned in the information bulletin of the NEET UG 2024. That is, now see, this is very important. If more than one option is found to be correct, then 4 marks plus 4 will be awarded to only those who have marked any of the correct options. So this applies in a situation that where 2 answers are found to be correct.
Yes.
If 2 options are found to be correct, then if you adopt any one of them, you will get +4. This is not a case where option 2 is correct. Only option 4 is correct.
Well, we are saying that as per option, there are 2 options which are jumbled in each set. So if both statement 1 and 2 are correct, and the today's version of the answer, as per this expert opinion, either or will be treated as correct if there's an ambiguity. Because our respectful submission is that if in case of this ambiguity, if now
plus saying that she will make it to AIMS Delhi.
Yes.
She will not go to AIMS Delhi, but someone. I mean, you take it from us that we are as sympathetic as anybody else. So we realize that, but it's too weak. It's not a situation where there's an element of ambiguity also. You see, there's not even an element of ambiguity.
My lords, may I just make a ambiguity is in the information bulletin. And in fact, this book is still now it's on the website. The ambiguity lies there that if there were instructions and this applicant
still on the website.
Or even civil services examinations, the students rely on NCR. It is considered to be standard. My Lord Justice Mishra is right. There is no
just the argument on principle. Let's assume that we don't want anyone to be disadvantaged. My lords, we want to consider what might be an overall solution over here. My lords, we're testing a competitive exam. We want to test everyone on the same basis. The version of keeping this the same. Keeping this the same, the best way would be to remove this question at all. Because then what happens is that in a competitive exam,
Your Lordship, the candidates who have answered it wrongly will be benefited of that negative marking, Your Lordship.
they won't get the negative marking. That's the advantage. Anyone, the negative marking won't affect them then. That's the advantage. The question is removed.
Just, talk to your directors here, right?
Yes.
You can ask him to write your assessments on this. What if we do this? See, with the IIT report now, it's getting us in the face. Now, can we in our order, assuming we are not setting aside the whole exam, we are setting aside the whole exam, all this is irrelevant. Then, of course, the whole exam goes. But assuming that they are wrong and assuming they are right on the whole exam, we will take a call out. What if we say that look, only option number 4 will be the correct option? But for anybody who answered option 2, there will be no negative mark.
Appears.
Would you just talk to Dr. Kamakoti and the director?
No, he is the director, IIT, bro. Your Lordship wants me to.
But just I'll talk to the director, NT on
NT.
In this regard, can I make a submission?
this one. I will get
I am for a petitioner wherein one student has scored 720.
That's correct. Okay.
720 and he has selected option 2. Here, June 20, the same book was there which was having the option 2 as the correct answer.
That's why what we are suggesting is that we don't give an additional negative mark.
I think, my lord, it's reasonable, my lord, with profound respect, my lord. It may, Lordship may ensure that it does not become a precedent. Otherwise, for every question, there can be a litigation, and I am appearing in some of the matters, my lord, where, no, not in this exam. Their questions and answers are disputed.
marks.
If there is this exam is for elimination of student for the best profession in the country, Your Lordship.
That's what
Anything more? Anything more? Or you
no, only one, but there was a faint but attempt to allege bias IIT Director Madras. We filed an affidavit that he has never attended any of the meeting. He is member of the general body of NTE.
Actually, Madras is a member of the general body of the
General body which takes a policy call, not
coordinating the exam this year.
no, it has nothing to do. But in any case, he asked somebody. We have a composition where whichever.
You said
Yes, we have filed an affidavit to that effect. Can you take that on record? And what we do is, as per composition, whichever IIT has organized JEE exam last year is our member to gain their experience. So last year was IIT Madras, therefore he came. Our affidavit note is.
you are just
He
saying
attended only one meeting, as far as I stand corrected, in December 22. But general body meeting for overall accounts, etc., not for conducting examination.
My Lordship.
I am appealing for a petitioner. There are 56 petitioners from Gujarat. All are right students. So what I have tried to do is I have shared one written submission yesterday.
so you have all got how many have got 720 out of that? You don't
721.
want a retest, you want a retest.
We don't want to.
You don't want a retest.
Most of the petitioners have been selected. They have scored more than 650. And I am also appearing for 6 intervention applications wherein 50 applicants are there. Out of those,
Then they've heard that now the solicitor has argued for your line of
and the facts are open. The only thing is that we have tried to make a written submission where we have tried to establish the background of all those candidates,
that's all.
10th, 12th and everything, because they
You're
are
not saying.
consistent.
Then
It's not only NEET.
you can't go into individual background because
That's what I'm trying to say is that not only NEET they have performed well, but there is an exam of good set. Even in those exams they have topped.
fair enough. Yes, Mr.
My,
Please,
my Lordship.
Yes, ma'am.
on a
Yes. Sir, I have a very limited purpose, sir. I seek to represent students belonging to tribal, rural, and basically remote areas and EWS categories from Madhya Pradesh. They are being represented by a socially minded teacher. She's a medical professor. Sir, the issue here is that we face is that these students, some of them come from very remote areas, some are even Naxal regions. For them to access an exam center or even sit for a test once is a very expensive exercise, leave alone doing it again. Some of them have even qualified and they have been seeking assistance from professors and guidance during the ongoing litigation. All we request is that if a retest is ordered, these students may kindly be either exempted or some sort of exception may be made for the process to be eased for them, sir, where their prior scores may stand in case.
Ma'am, if we order a retest, we can't create an exception. Then logically we will be incorrect.
My lords,
Either we do it, we have to use the same yardstick for everybody. the fact that there may be students like your candidates coming from tribal areas, poor students will have to go through the entire process, may be a ground not to order a retest. But if we order a retest, then we can't start creating any exceptions. Then there'll be our judgment will be very vulnerable. We then have to apply one cut across it.
My lords, in that case, I seek my lord's permission to assist my lord with the judgment.
Your first point that this may, you take it as a point that ordering a retest
Sir.
will substantially prejudice students, especially students coming from the poorer background, marginalized background,
Sir.
like your plan. That point we took.
Sir, with your permission, if I may put forth my lord's observation in Sachin Kumar versus DSSB, which learned solicitor presented. So basically, by your lordship's principle, these students are obviously not beneficiaries of any paper leaks. And if they are put on the same yardstick as the wrongdoers, then it will be a violation of Article 14. That is my lordship's observation in the matter. And such an exception has been made by the judicature of Patna in Bihar STET leak.
Because then you belong to, say, tribal students. There may be Dalit students. There may be OBC students who also come from a very underprivileged background. Then where do we draw the line? There may be disabled students. Drawing a line becomes very difficult for the court, becomes a little arbitrary. So,
I would seek your consideration.
We've seen your first point. We'll
my lord.
just take it.
Oblige.
Thank you. What's your name, ma'am?
Tanushri Bhalla. Oblige.
Your Honor's permission, may I just make a submission? Your Honor, I will take less than 10 seconds. I'm appearing in IA number 140274 of 2024 in the lead matter. Lord, I adopt the submissions which have been made by other contestants. I am also appearing for an applicant who has secured 658 and he is opposing the conduct of re-neet. He opposes scrapping of the exam. The important thing why I'm addressing the Honorable Court is, my Lord, that there have been instances where unsuccessful candidates have approached high courts, sought orders against the NT, and the high courts have judicially determined that such prayers are being made on the basis of false and fabricated documents. And in my IA, my Lord, I have appended the order passed by the Honorable Allahabad High Court on 18th of June. When a petitioner approached the High Court, he sought scrapping and all those reliefs, stay of counselling. The NTA appeared, produced original documents of the candidate. And it was eventually then the petitioner's counsel sought to withdraw the petition. And the High Court was kind enough not to penalize the student for filing fabricated documents. So, my Lord, the only submission is that this entire exercise, bona fide students are suffering. And some...
Thank you. Lord, yes, basic principle which has been laid down by this Honorable Court is, if there is a leak, blood, in this case, leak is admitted. If after the leak...
Be excused for 10 minutes.
Yes.
After the leak has happened, and the leak was done by the gang head who has not been arrested, Sanjeev Mukhia. What is there in public domain, the CBI has not brought it on record. This Sanjeev Mukhia, who is yet to be arrested, is involved at least in 5 major paper leak cases in UP, Haryana, Rajasthan. These are the news items. It is to be verified by them. He has not been arrested. The moment it is established that leak has happened, dissemination is through WhatsApp mode. The handiwork of a gang operating in different states. Now, Government of India taking a firm stand that the leak is now, the beneficiaries of the leak are confined only in Hazaribagh and Patna. And this confidence emanates from only and only one fact, that the accused in custody so far have said that the leak is confined to Patna and Hazaribagh. Patna police, when records 161 statement of the accused, they talk of leak prior to the date of examination. This is also 161. Subsequent 161 statement recorded by CBI probably indicates that the leak is on that date of the examination. Now, when the CBI officer was talking to this Honorable Court, his expression, as I could gather, was that so far we have not been able to recover the mobile phones through which this dissemination happened. So we cannot say with confidence that this dissemination happened only in Patna and Hazaribagh and not beyond that. So unless, because after the leak has happened, the question paper is sold and there is sufficient time, even if the leak has happened on 5th, then this honorable court ultimately, if sustains this examination, will have to record, in my view, a satisfaction on the basis of the material before this honorable court that we are able to segregate tainted from the untainted, and this satisfaction this. Is completely baseless. Investigation is going on. Can they file an affidavit that henceforth there would be no investigation to see whether it has gone beyond? If tomorrow, today the judgment come, tomorrow this Sanjeev Mukhia is arrested along with the mobile, which would show that he had sent it for 200 people in Sikar. or different stations. I got to know that from Patna people have gone to Muxar, Punjab to give a paper. And if here they say 4 locations they have been able to find. Suppose there are 100 more locations involving only say 1,000 people involved into 20 centers. How many people would those figures, if all of them have got, all of them will not be topping, all of them will not get 720.
Look at this as one aspect. The court cancelled the examination today on the hypothesis that the investigation is not complete. The main conspirator is yet to be arrested.
That's right.
And there may be a possibility, we can't say likelihood, but a possibility that in some future point of time, maybe even a foreseeable future, the leak may not be only confined to these two cases. But the court, in a situation like this where 23 lakh people a year, and we are dealing with the welfare of students across the country, that's the only part. And we put it this way, both ways. Let's put it 1 second. Let's put it both ways. We can't, today you are right, absolutely, that we can't say that a leak, we can't enter a judicial finding that the leak is confined only to Hazaribagh and Patna. For the reason that the investigation is ongoing. Even CBI can't tell us that. Today, as of now, it is confined to Hazaribagh and Patna. CBI's investigation in the next 15 days or 10 days might reveal a different and evolving thing.
There are more locations.
So, we also, on the one hand, can't say that the leak is confined only to Hazaribagh and Patna. Equally, we can't today say with any degree of even prima facie authenticity or substance that the leak has gone beyond Hazaribagh and Patna in such a widespread or a systemic manner as to completely affect the sanctity of the entirety of the exam. That also we cannot say. Therefore, I asked you the question, that's why we want your assistance. Can the court, or would the court be justified in a situation like the one present to say that not on the basis of material which we have today, but on the hypothesis that some material in the future may show that the leak has gone beyond Hazaribagh and Patna. Therefore, today we cancel the exam on the basis of the hypothesis.
May I answer, my lord?
What happened in future?
May I answer? When I wanted to speak, your lordship will speak.
So please sit down.
No, I'm among the lawyers here, I am the senior most.
Sorry, you're not an amicus. I'm not appointed.
No, I'm appearing for 16 students.
Okay.
When I wanted to speak, Honorable Chief Justice prevent me from speaking. And I have an answer.
He is arguing. You will not interrupt him when he's
I am not interrupting, but I have an answer to say. I have an answer to give.
You don't answer my question. He's answering the
Okay, then it's a general question. It's a general question. No, I'm not interested in engagement with the Honorable Chief Justice, but I wanted to say.
You please sit down. I'll have you removed from the floor. You please sit down. I'm warning you. I'll have to have you removed from the
Your
floor.
lordship doesn't respect me. My own will leave.
Mr. Matthew, I'm telling you one very simple thing. Mr. Huda is engaged in a...
Your lordship, I've tried every best to allow me to speak and
right to intervene.
I'm not intervening, I'm leaving. But one thing is said, I wanted to say, I was allowed to speak.
Yes,
When I was speaking, your lordship was showing the other side, and I have only one word to say. Only one word to say.
Please call the security department.
I have only one word to say.
You will not say anything. You will not speak to the gallery. You will listen to me. I'm in charge of my courtroom.
Listening.
You just keep quiet now. Yes, Mr. Huda. Yes, Mr. Huda. Yes, Mr.
I'm leaving.
Yes.
Unfair.
Yes, Mr. Huda.
This is not a duty.
Mr. Matthews, I will now be constrained to issue something which is very unpleasant. Please keep quiet. Sit down here. You want to leave? It's your choice.
I'm leaving.
You don't have to. Do not have to intervene. You don't have to tell me that you are leaving.
Because I sought permission. I sought permission to speak.
Matthews, you will not interrupt Mr. Wood's procedure in this court. And I've seen this court. I've seen the judiciary for the last 24 years. I will not allow any lawyer to dictate the procedure of the court.
I say
I will give you a full hearing, but after Mr.
all right. I have been judiciary since 1979. Since 79.
This is contemptuous.
My response is straight away.
I am leaving.
Issue is no longer res integra.
Yes.
This has been answered in para 20 in Tanvi Sarwal's case.
Yes.
And the proposition is like this. The moment this honorable court finds that there is a paper leak and the fact has been established that it is a paper leak, in that situation, unless and until the honorable court reaches a firm conclusion that we have been able to identify all the culprits and there is nobody left in the system who has from a back door is entering and becoming a doctor, unless that satisfaction is recorded, no, this is my proposition for my lord's consideration, the examination cannot be sustained. And here, not only one fact, I'm just putting all things together, not in a circle. Let me put all things together in a circle.
Your argument is that unless the court comes to the conclusion today that all the tainted persons are identified as of date, you have to order a rehearing.
Correct. That's my proposition for my lord's consideration. Now, my lord, I put it in a sequence. Especially in the effects of this case when the handiwork is of a gang operating interstate. No denying the fact. No denying the fact that the main mastermind is yet to be arrested. No denying the fact that the mobile phones used for dissemination of sold question paper have not been recovered. This will not coupled with the fact which I have pointed out, but the reference, the learned Solicitor General, the analysis did, IIT.
Okay, class. Any questions?
Ma'am,
NTA in their reply before this Honorable Court on affidavit says that CPI is investigating the matter. The conclusive opinion as to whether it was a systemic failure or not, that conclusion can be arrived at only after comprehensive analysis of everything. This is their reply of NTA in para 9 of their reply. So they are not sure themselves that whether it is a systemic failure or not. They will come to this conclusion after the CBI investigation. Now, in Tanvi Sarwal case, I just want to read 2-3 lines for consideration. Para 20. It says, even if one undeserving candidate, para 20, just allow me to read 2-3 lines. Para 20. Even if one undeserving candidate, a beneficiary of such illegal machination, though undetected, is retained in the process, it would be a denial of the claim of more deserving candidates. At present, the examination stand denuded of sanctity. Now, as on today, I would say the whole world is watching. Paper has been leaked by a gang. Investigation is happening. Mobile phones are not recovered. Is there any sanctity left for this examination? Merely the figures are being thrown before this Honorable Court. Only the figures are being thrown before this Honorable Court that if re-examination...
Figures before the court. We never throw figures.
Yes, 23 lakh people will be affected. They say that 23 lakh people will be affected. No. It is not even the first 56,000 people who get the medical colleges. The rest all want a again chance. When they are comparing the figures, they are talking of 1,08,000, and everything is being their reference sometime to 23 lakh people, sometime to 12 lakh people, sometime to 1,08,000, sometime to 56,000. Sometime they categorize from 663 marks, sometime 550. They are clicking picture wherever they get the best photograph to justify on the data. That if we take from this angle, this seems 0.5%, it may be justified. A leak case where it's not even 1% of the total people who wrote the examination are involved. Not even 1% will be 23,000 people. Even if there are 1,000 people who are beneficiary of this machination, there has to be a retest. So, we are finding a imbalance in a haystack where there are few needles here and they are inserted into the system. You will not find that imbalance. I conclude here on a leak that saying that the integrity has actually gone. We can't reach a conclusion that everybody has been identified and rest all are pious people and they should not be bothered any further. Now, Lord, I come to their systemic failure, Lord, which I raised in my second petition. Lord, in my first petition, I came only for leak. Lord, Justice Bhartiwala rightly pointed out. We came only for a leak. But Lord, with the passage of time in this Honorable Court granted us time. Now, Lord, what we have found is there is absolutely no system in place for conducting this kind of an examination. Taking example of Lord Bahadurgarh, where now after flip-flop from yesterday, what they said, they changed 3 statements in the court itself. Now the statement is, with regard to, there were 3 centers. This I'm saying not as an individual instance. This I'm demonstrating that there were no systems in place for conducting this examination. And for this reason also, this examination has to go. If NEET is a patient, it suffers from a multiple organ failure and the patient has to go. Now, talking of Bahadurgarh, they say there are 3 centers in Bahadurgarh. There is only one city coordinator who is authorized to collect paper. Now, for the 2 centers, they say the SBI paper was collected. Given to those 2 centers, there was some delay in distribution. So at what level they took a decision to grant extra time then and there? Who took that decision? That there was not all this, like superintendent in Hazaribagh colluded with these accused. All these superintendents and invigilators and the city coordinators are private people. They are charging 2,000, 2,500 from the NTA and performing their job. Now, they are the people on the spot. Are they taking the decision to extend time that these 2 centers? Yes, Lord, I'm just rapidly concluding. These 2 centers, they extended time. Only SBI paper was given. Hardyal School, the curious case. Now, in their note, what they say is that for Hardyal School, the paper distributed amongst the student was both SBI and Canara Bank, both papers were given to the students. But this is what the 2-page note they have given today. They say at Hardyal School, Jajjar, initially both set of questions paper were distributed. What is the system? I fail to understand. After some time, SBI question paper was withdrawn. No, who gave these instructions that SBI paper is to be withdrawn? If not, SBI paper was the actual paper. If at all, Canara Bank was wrongly distributed, Canara Bank should have been retained. But they say both were given, meaning thereby there is absolutely no sanctity. SBI is withdrawn, Canara is allowed to do. But we have a video on record on which they have not commented the principal of this school, and we have the video. The transcript is on record. But let me say what she says. She says there is not a minute delay. Canara Bank paper was distributed. After 47 minutes or 50 minutes, we got to know that it should have been SBI. We contacted the agency, NTA, and they said, now its time has gone, now let them attempt Canara Bank. And we allowed them to attempt Canara Bank. The principal of the school is on record, and we can run the video just now. Now, in order to overcome of this, because they, after allowing the Hardyal School people to attempt Canara Bank paper all the time, they also gave them the grace marks. And they are not able to justify, because yesterday when this question was put to them, that's right. What I say, that's a different issue. What I say is there is absolutely no place in system. Somebody attempted Canara Bank paper, the entire 3 hours and 20 minutes, NTA grants them grace marks. Then they unilaterally withdraw the grace marks, and before this honorable court, they say, we committed a mistake, we committed a blunder, now we are withdrawing it, we are having a retest. This honorable court, the other coordinate bench, only says that, all right, you are withdrawing grace mark, you are having a re-examination. Fine, go ahead with it. But there is no adjudication that how they picked up 1,563 people, first to give grace marks and then to withdraw and a re-examination. There is another important fact which they have not brought to my lord's notice. Out of this 1563, 773 people were those people who could not make it even 164 marks. They were failed. After compensatory marks, they could not get even 164. They were allowed re-examination. All students have to be put at par. And ultimately, Hardal School participated in re-examination. Now, with regard to 3,307, they say the Canara paper was given. I want to demonstrate that for their percentage, there are no two question papers which are at par with each other. Cannot be, in my humble submission. And this Canara paper, of course, they knew that it's not to be used, but wrongly used. Now, curiously, in this 2-page note, they say, out of 3,307 candidates, 7 candidates have secured more than placed before this honorable court today by the learned is with reference to 164 marks. For this 3,300, the reference point is 622 marks. And 622 marks out of 56,000 candidates. Probably this is the best picture they could paint here. Now, how these 60, what is the average of SBI paper, people securing 164 marks? And what is the average of people who attempted Canara Bank? How many on the touch 164 marks? They have not given this data. So there is no parallel. Can't be. So this vitiates the integrity. Now, going, I'm just rapidly wrapping up. Going back to Rajasthan, Savai Madhopur and Ghaziabad. These students, they say late loss of time. The same day, the answer, the OMR sheets and question paper were there with these students for 6 hours, first 3 hours, 20 minutes, and later on the full time. How they can be said to be at par with the other candidates who had to attempt the same question paper? It was the SBI question paper was given to them in the morning session at both places. Ghaziabad, they refused to respond. Even Savai Madhopur, what is the justification for the same day and who took that decision? Now, they say that, all right, all these people, these invigilators and city coordinators are all private people, but we control them through CCTV camera. They are on affidavit before this honorable court saying that we got to know at 4:30 from social media that there was a loss of time in Savai Madhopur because a wrong medium question paper was given. Where is the CCTV camera? Why couldn't they come to know that there is a wrong question paper given to the people for 2.5 hours? And their reliance is on a social media for this. The same thing happened in Ghaziabad. So what is their system in place? Another thing, I pointed it out, which they have not responded back. Now, after how that certain centers are performing extremely well, especially now the comparison the Solicitor General was drawing between quota and quota and the same amount of the total candidates were the same 27,000 at both places. But may kindly see the difference in the result between quota and seeker. It's more than 50% in every respect, on all angles. So the seeker has an advantage. Now, how it is happening, and maybe it is happening consistently. This time they are caught. The argument was that if we see the data with reference to the previous year, 2022-23, this time is no bump. I say this is happening consistently, even maybe previous years, because after 520, what is the mechanism? They have prescribed in the SOP that how soon the OMR sheet will be seen. These are the schools with no boundary. Only one is Kendriya Vidyalaya. There is no government school. There is no government teacher. There is no police involved there. And now after 520, the OMR sheet and the question paper is there with the invigilator and the center superintendent. And they have a teacher, biology teacher, physics teacher there in the center and say, now we will deposit it in the city center somewhere and we can deposit it by 8:30. And in the meantime, all right, if more, let them attempt 10 more questions. And look, all of them are not for M, because the merit goes, the people who get admission, the merit goes even up to more than 10 lakh in the BAMS and dental colleges, etc. PDS. Last time, I'm told it went up to about 12 lakh. So we are looking for the spots where the people are getting 100% or 700 or 650. No, but this is also a breach. If somebody is able to attempt 10 or 20 more questions. So the system, I would say there is no system in place. And it is too easy to manipulate. And with this kind of a system which the NTA on roll, their employees are about 22, about 33 are on deputation. And rest is all they keep on issuing checks from here. Some videographer in Seeker is hired, check is given, and now how good the job is performed, there is nothing to monitor. Now, an examination with this kind of checks and balances, I would say it's completely farce and can't be upheld. And just one thing to add. Now, it is a coincidence, I read to this Honorable Court the news item which showed the e-rickshaw. Straight away, the news item was CBI. CBI is here, they will confirm that this e-rickshaw carrying the question paper, because question paper, there's a test booklet which contains.
The report number 3 gives that photo, clarifying that it's not a question paper, it is the OMR sheet.
I can clarify just.
Where 129, the same photograph saying that this.
Just hold on, I'm just wrapping up 2 minutes.
Yeah,
what the submission is now, I did
in my status.
My submission is there is a report and let the CBI respond to it with no filters in between. OMR sheet and question paper is in the same envelope, Lord Hazel. It is never ever separate. And the report specific is that instead of this private courier company, instead of taking the question paper on 3rd of May directly to the SBI and Canara Bank, it took it straight away to this Oasis school where the breach takes place. On 3rd of May. Now, what is the investigation on that angle? But if I can invite your kind attention to the news item, this is a Times of India. This is Times of India. Page 12 of my first supplementary note. I have placed the Times of India report. If I can just read a few lines from here. The sources told TOI that CBI attention turned to Oasis School located in Mandai Road, Kali Chowk, and its staff. The agency began gathering digital evidence and discovered that e-rickshaw had gone directly to Oasis School on May 3rd instead of proceeding to the SBI main branch where it was supposed to be stored. This is a report quoted by Times of India from the source of CBI. Now, what they say, except saying that it is